The next case out of the ninth that I was thinking about was Castillo v. Barr, published by the ninth on November 18th. And this is an asylum case, but I think it's really good for an appeal. It's really good for appellate arguments. It mainly deals with expert testimony. And as I said on the Immigration Review podcast, it seems to create a bit of a landmine for IJs and the BIA that they need to avoid, because the quote is this: if the board rejects expert testimony, it must state in the record why the testimony was insufficient to establish the probability of torture. Improperly rejected expert testimony is a legal error and thus per se reversible.
Wow.
End quote. So, I mean, if you're doing an appeal, so if something is per se reversible, that's about as good as you can get, right? So yeah. When there's an expert involved, it looks like an IJ and the board need to be on high alert. And practitioners should know that there are strong legal arguments, at least in the Ninth Circuit, but also in other circuits when expert testimony is rejected. This is important because the board is also getting into expert testimony decisions, creating case law in this area where the board hadn't really created case law in the past. And now it seems to me that the board is treating expert testimony similar to how expert testimony is treated in federal court, which is pretty deferential once you qualify that expert as an expert. How much weight you give to the expert testimony is always in the judge's discretion. But once they're qualified, an IJ has to do certain things if they want to reject that testimony. And the Ninth is making clear that if they mess up, that's per se reversible.
Well, I guess every practitioner has to bring an expert testimony now to court no matter what, because it's good to have that backup just in case
right.
the judge messes up. I mean, I've never had a case where I brought an expert testimony. How valuable is it? I mean, a lot of times you have the documents, you have the records, and have you used expert testimony in these kind of cases?
Well, I recognize that a lot of practitioners never do experts. I've had the good fortune of working for Ira Kurzban, and a lot of our clients do have some means. We rarely go to an asylum individual without an expert. Because to me, it's very hard to prove what's going on in these countries, especially with how important social distinction has become to the particular social group analysis. The board really is saying you need to put yourself in that country and think about how the society is viewing the purported particular social group. And I don't know how you really do that without an expert, unless it's a country like, say, Iran or Venezuela, where the Department of State reports are so solid that you have a much better case. But other than that, you bring in human rights reports or Amnesty International or newspaper articles. Those are all going to be given diminished weight by immigration judges if they like and if they have proper reasons to do so. So we usually come in swinging with an expert, and presenting that testimony is an important thing. Doing it right, I guess. And the Ninth Circuit is recognizing that. But I recognize it's very expensive to do so, and a lot of clients don't have that means.
How much does this kind of stuff cost,
Yeah, it depends on the expert. An affidavit from an expert without testimony, which should also be given weight, but it might be hard to qualify just an affidavit as an expert, but not impossible. An affidavit will run between $1,000 and $3,000, and their in-court testimony before costs might be another between $1,000 and $3,000. So it gets expensive. If you get a proper expert.
Yeah. Well, it seems the Ninth just created a lot more work for these experts. I guess
right. No, but that might be how you win your case. Yeah. And I recognize experts are expensive, but there's this last quote from this case as well, which isn't just limited to expert testimony, and that is, where the board does not consider all the evidence before it, either by misstating the record or failing to mention highly probative or potentially dispositive evidence, its decision cannot stand. I mean, again, just great quotes for appeals. When you really wrap yourself in all that evidence and you find something that the board, that's material that they did not consider, again, you've got some strong arguments to reverse on appeal.